In this video, we will introduce mediation. Mediation is a process where parties in a dispute select a neutral party, a mediator, to help them resolve their dispute. The mediator facilitates negotiation so the parties can resolve their dispute. Let's say Patty and David enter into a contract, but there is a dispute, and Patty accuses David of breaking the contract, and David accuses Patty of breaching the contract. Now, they could go to court, but litigation can take a long time. It can also be expensive. Also, litigation is public. Other people will know about it. And in a litigation, the parties can't control what a jury or judge will decide to do. So perhaps Patty and David will not want to litigate now, but if the parties don't want to go in front of a judge, what can they do? Well, they could try to negotiate and settle their differences, but sometimes parties in a dispute have trouble negotiating with each other. And that's where a neutral party, acting as a mediator, can help. So let's say we have a neutral mediator named Mary. As a mediator, Mary's job is to help the parties negotiate. The mediator helps the parties reach an agreement, but she doesn't compel the parties to settle their case, and she doesn't decide who should win the case. So in our example of Patty and David, they won't go to court for now, and instead, they'll meet at Mary the mediator's office. In this more informal setting, the mediator will try to help the parties negotiate. During the mediation, the mediator will probably speak to both parties in front of each other, but she'll also probably speak to each party privately. Keep in mind, at mediations, parties are often represented by their attorneys, and all discussions in a mediation are treated as confidential. If the mediation is successful, the parties will reach an agreement, and they will probably sign a settlement agreement. And for many parties, this is the value of mediation. With the help of the mediator, the parties control whether and how the case ends, not a judge or anyone else. And because courts are so busy deciding cases, judges will often order the parties to try mediation. And of course, if the mediation does not succeed, the parties will continue their case in court. To summarize, mediation is where a neutral party facilitates negotiation between disputing parties. The mediator does not decide who prevails, but helps the parties agree on terms to settle their dispute. Mediation can help parties save litigation costs and lets parties control the outcome of their dispute. Courts may order parties to try mediation to help reduce the court's caseload.
Good evening, everyone. I am Andrea Ivan P. Maborang, and I will be the first reporter of Group 2. We will report about the DHSUD, or the Department of Human Settlements and Urban Development Mediation Salient Points. The Board Resolution number 963 series of 2017, or known as the Revised Rules of Proceedings before Regional Arbiters. So as a background, what is the HSUD? Actually, this is the Central Housing Authority of the Philippines. It has absorbed the duties and functions of the Housing and Urban Development Coordinating Council and the Housing and Land Use Regulatory Board. So the current secretary of the DHSUD is Secretary Eduardo Del Rosario. So let's go to the salient points. First is the objectives. There are 4 objectives. The objectives of these rules are: first, to protect and promote the constitutional right of persons to the speedy disposition of their cases. Second, to provide a simplified and inexpensive procedure for the resolution of cases. Third, to streamline the adjudicatory processes, to provide immediate response to the grievance of the citizenry. And fourth, to introduce innovations and best practices for the benefit of the underprivileged. So as you can see, these objectives are in line with the ADR Act of 2004, wherein the state, diba, it actively promotes and encourage the use of ADR, or alternative dispute resolution, as an important means to achieve speedy and impartial justice and declog the courts, the clerk dockets, and as such, the state shall provide means for the use of ADR as an efficient tool and an alternative procedure for the resolution of appropriate cases. So as you can see, this board resolution is one use of ADR. It is an efficient use of ADR because are the objectives, diba? They are really eyeing for speedy disposition of cases, so they don't have to go to the court because it could be settled administratively. So moreover, in the fourth objective, to introduce innovations and best practices for the benefit of the underprivileged. Because why? Because there is no need for them to go to the court, so they no need to pay other fees like the docket fees, the appearance of the legal counsel. So it really helps the underprivileged, not just the underprivileged, but the system itself, to resolve cases using a simplified and expensive procedure, and again, to have a speedy disposition. So next, construction and applicability. So in section 4, this rule shall be liberally construed towards the accomplishment of its objectives. So any act that could help to simplify or to achieve all the objectives that was stated in the previous slide, then it will be liberally construed to it. So, and it shall apply to all proceedings where jurisdiction is vested on the arbiters, except to the orders of the regional field officer in the exercise of regulatory jurisdiction, which are directly appealable to the Board of Commissioners. So, let's go. What is the jurisdiction of the regional arbiter? So, in section 5, arbiters have exclusive jurisdiction over disputes involving laws being implemented by the Housing and Land Use Regulatory Board and such other cases as may be provided by law unless specifically vested in other tribunal. So as a general rule, all cases or disputes that is implemented by the HLURB, then the regional arbiter has jurisdiction over it. So what are the specific jurisdictions? So when we say specific jurisdictions, these are the disputes wherein no other tribunal could handle the case except the regional arbiters. So jurisdiction, so the following are the specific jurisdictions of the regional arbiter. First, jurisdiction over real estate developments. Real estate developments like mga subdivision, mga condominium. Next, jurisdiction over homeowners and homeowners associations. The arbiters shall exercise exclusive jurisdiction to hear and decide cases involving homeowners associations. Next, for real estate development. Number 1, claims for refund, complaints against unsound real estate business practices and other actions for specific performance of contractual and statutory obligations filed by subdivision lot or condominium unit buyer against a project owner, developer, dealer, broker, or salesman, and other complaints for violation of Presidential Decree number 957 and other related laws. So what is this PD 957? PD 957 or is known as the Subdivision and Condominium Buyers Protective Decree. So if you have any problem, for example, you bought a land or in a subdivision and then the developer was not able to fulfill their obligations to you, so you can go to the specific the jurisdiction belongs to the regional arbiters. So next, suits filed in opposition to an application for certificate of registration and license to sell, development permits for condominium projects, clearance to mortgage or the revocation of cancellation thereof, and locational clearances, certification, or permits when issued by the Housing and Land Use Regulatory Board. So all these suits, these suits were in the subject are the following, then the regional arbiter has jurisdiction over that. The next, suits filed by the project owner or developer or the duly registered homeowners association of the project pertaining to the open spaces or common areas of the subdivision or condominium, except those where third parties are involved. So if it is in between, diba, the project owner developer versus the homeowners association, then it could be resolved or the regional arbiter has jurisdiction over it. But if there is already a third party, remember, just take note, this pertains to the areas of subdivision or condominium, the open space or common space, like yung sa gazebo, yung pools, ano pa bang, common areas like the roads. So it is under the jurisdiction of the regional arbiter. And fourth, disputes involving easements within or among subdivisions projects. So when I say easements, like yung right of way, yung sa drainage, so, yan. Next. So for homeowners and homeowners association, so yung homeowners, yun yung mga nakatira in the subdivision. The homeowners association is yung the group. Diba? Because when we, as you can see in different subdivisions, lalo yung mga high-end or big subdivisions, they have their homeowners association that wherein they also have their own projects. This is the avenue where yung mga fees, diba? May monthly fees, monthly dues tayo sa subdivision for the security, beautification. So, yan. So, what are the cases under the regional jurisdiction of the regional arbiter? So, first, suits filed in opposition to an applicant for or the revocation of certificate of registration of homeowners association. So, for example, ayaw nyo sa homeowners, yung homeowner ninyo na nagtayo sa sarili na association. Next, intra-association disputes or controversies arising out of the relations between and among members of homeowners associations, between any or all of the homeowners association of which are the members, including federations and other umbrella organizations of homeowners associations. So third, inter-association disputes. So dalawang association, they have a dispute, so it is under the regional arbiter, arising out of the relations between and among two or more homeowners associations or condominium corporations, federations, or other umbrella organizations of homeowners associations. Fourth, disputes or controversies between the association and the homeowners or other beneficial users relating to the exercise of the respective rights, duties, and obligations. Fifth, disputes between the homeowners association and the state insofar as its registration or right to exist and those which are intrinsically connected with the regulation of homeowners association. So again, let's have a recap sa homeowners association and homeowners. Ano yung mga ano yung mga pwede? So first is for the application. If for example, there's um a group of homeowner and they want to establish a homeowners association, so their certificate of registration, their application, so it is under the jurisdiction of the regional arbiter. So intra-association, so within the homeowners association and its members, so it is also there. The next, inter-association, so meaning two homeowners association, they have a dispute. And then fourth, dispute are going to be between the association and the homeowners. And then fifth, the homeowners association and the state. So what are the powers of the regional arbiters under this board resolution? So in section 7, first, to hear and decide cases cognizable by HLURB consistent with these rules. So, yung cases kanina like yung sa homeowners and the homeowners association together with the real estate development. So, those cases, so the regional arbiters has the power to hear and decide those cases. Next, to issue a cease and desist orders or writs of preliminary injunction, whether prohibitory or mandatory, in all cases in which it has jurisdiction. So in all those cases mentioned a while ago, so the regional arbiter has the power to issue a cease and desist order or a writ of preliminary injunction. So yung it is a temporary order wherein the other party is prohibited to make another move or to do another course of action until the case or the dispute is settled. So next, to punish for contempt, both direct and indirect, in accordance with the pertinent provisions and penalties prescribed by the rules of court. So when I say contempt, or direct or indirect contempt, so when you don't behave well in court or during the proceedings, then the regional arbiter has the power to punish you for contempt. Next, to issue subpoena duces tecum and summon witnesses to appear in any proceedings and in appropriate cases, order search and seizure or cause the search and seizure of all documents, papers, files, and records, as well as books of accounts of any entity or person under investigation as may be necessary for the proper disposition of the cases before it. So all those cases mentioned a while ago, then if there is a need to get hold of documents or to conduct a search and seizure in order to resolve the case or for the proper disposition of these cases, then the regional arbiter has the power to do it. Next, to impose fines or penalties for violation of the laws and rules of regulations, orders, and decision or rulings. And next, to suspend or revoke after proper notice and hearing the certificate of registration or license to sell upon any of the grounds as provided by law, including fraud in procuring its certificate of registration, serious misrepresentation as to what legal entity can do or is doing to the great prejudice of or damage to the general public, refusal to comply or defiance of any lawful order of the HLU or B Restraining Commission of Acts which would amount to a grave violation of its registration, and lastly, to exercise such other powers as implied, necessary, or incidental to the carrying out of the express powers granted to the board or to achieve the objectives and purposes of the exercise of jurisdiction. So, all these powers belong to the regional arbiter in regarding the cases under its jurisdiction.